DLCCS, DLC Consulting Services, and we have LawPay and Thomson Reuters as our sponsors. As Ann said, this is the 6th in our roadmap series, and after this one, we will be taking a couple months break with coming back in September with a presentation on work-life balance. This seminar, as all of them, are being recorded for video, so it will be available through the BAR website within the next week or so. We get those up pretty quick from Zoom. If you have any questions for the panel tonight, please put them into the chat window, type them in, and the panel will attempt to answer them as they're presenting. So with that, I want to turn it over to Craig Nevin. Thanks, and have fun tonight, Craig.
Thank you. Stand by in case we have technical difficulties, please. Hi, everyone. I looked through the attendee list and I recognize so many names. Good to see you tonight. I'll get to introducing my presenters in a minute. I wanted to thank them and really acknowledge that starting at one place, one of my favorite parts of putting this together was putting the bios together. And what I recognized about Judge Mockler, Judge George, and Matt is there's a very deep commitment throughout all of their careers to community service, civic acts, selfless acts, and it was fantastic. I'll describe their backgrounds briefly in a moment, but another takeaway I got was when I was pulling the presenters together, I received a 100% response rate. Everybody that I asked said that they would help, that they would present, that they knew ethics, civility, and reputation were worthy of talking about. And one of my takeaways was I knew when I called or asked Matt, asked Judge Mockler, asked Judge George, that they would probably say yes. I actually knew each of them either personally or professionally or both. And here was my reminder. I knew that if I didn't know them, they were a phone call away. We are in an area where if I don't know someone and you don't know someone, you're likely to pick up the phone, call a few colleagues, and you'll know someone who knows that one. That's a unique area to have that advantage. But it's also an area or a reason why a lot of us do worry, concerned, rightfully, about our reputation. So rather than just platitudes, I'm not going to talk much. I want the judges to talk about ethics, civility, and reputation. I'll put in some of my 2 cents. I'll put in how different it was when I cut my teeth and started practice in LA and Orange County, and it truly is different. But we'll get to that. First, to introduce our speakers, first is Judge George. She began and continued her legal career for, if I did the math right, about 14 years as a deputy DA in the Contra Costa DA's office. When you read her bio, some other things you'll notice is that she was also a law professor at JFK University School of Law. She was an executive director, and if I recall correct, founder of their elder law clinic. And while then moving towards and becoming a judge in Contra Costa, she pro tem'd in Contra Costa. And I think if I could have everybody nodding, although I can't see you, everybody would say, yeah, we know that. We know that about her and we know her reputation. Judge Mockler, as you'll see when you see her bio, her pre-bench experience includes 29 years as a public defender, 27 of those in Contra Costa County. She mentors at-risk teenage girls through the county probation department. She has tutored Afghan women in English. She's on the boards of the Contra Costa Scholarship Fund, the Richmond Law School Academy, the Richmond Schools Law Academy, and a member of the Inns of Court. Again, a robust civic desire to help. Lastly, Matt Guichard is a nationally recognized trial attorney and founder of Guichard, Tang, Corteo, and Garrett, a full-service law firm offices in Walnut Creek in San Francisco. What I also learned about Matt is he's a hearing officer in coroner inquests. He's a state bar fee arbitrator, a member of the Contra Costa Fire Protection District advisory board, board member of the Walnut Creek Chamber of Commerce. It goes on and it goes on and it goes on. So two of my takeaways were everybody here seems to have this deep vein of civic duty and I think a reputation for it as well. Secondly, I found everybody willing to participate. And to Judge George.
All right. Good afternoon, everyone. I'm going to introduce Craig Nevin. And Craig Nevin is a seasoned trial attorney who brings a unique and client-centric focus to all of his matters. He has both real-life practical experience as well as in-house counsel experience in the fields of construction and of real estate development. He uses these experience and his knowledge of the litigation metric management system to deliver excellent results. From October 2001 to May of 2009, Craig was a special master to the courts of San Francisco, Alameda, and Contra Costa counties. He has been designated as and has testified at trial as an expert in real estate in many civil trials, as well as in a criminal murder trial. So thank you, Craig, for being our host this evening. I'll turn it back to you.
And I'm going to turn the mic over to Judge Mockler.
Good afternoon, everyone. Thank you so much for attending this wonderful presentation, even if it's through a virtual setting. Zoom is an interesting way to have educational presentations. We'll give it a go. So my first topic is on topics are on etiquette in the court and on the types of conduct that a judge must report an attorney for to the state bar. So before I get into the draconian, what we have to report, I want to talk a little bit just generally about etiquette in the court. I cannot underscore this enough, but what you do and how you act in court, whether the judge is on the bench or not on the bench, has a tremendous impact on how you are viewed by not only the judge, but the court staff and your peers. We are, all of us judges started out as attorneys. So I know of what I speak, and I was a trial attorney for 29 years, appeared in a lot of different courtrooms in front of a lot of different judges. And I learned from personal experience that my reputation made a big difference to my clients. If you have a good reputation with a judge and you come into court someday with an emergency request to continue something because of, oh, your water heater broke, or you've got a problem with your children or with a pet or what have you. If your reputation is good, the judge is not going to blink an eye and is going to say, okay, fine, no problem. But if you're one of the attorneys who has gained the reputation for being rude to staff, to being belligerent with opposing counsel, you're not going to get quite the same accommodation as you might otherwise get. So what you do, how you act, what you say in court has a great impact on your life and your clients' lives. Also, of course, you all know that court staff, as well as judges, they talk. So if you are an attorney who always is above reproach, the judge, can just know that whatever you say is straight, just a straight shooting statement. It goes a very long way. Don't forget the staff. I remember when I was a very young public defender, actually started my public defender career in another county, but I never forget one of the first pieces of advice I got from my colleagues was be nice to the court clerk, be nice to the bailiff. They have a great deal to do with how your experience in the courtroom is going to play out. They have a great deal, whether you like it or not, it could even impact on whether your case is called first or last. So don't forget that it's not just the judge that you have to be respectful towards, but also their staff. Another thing you should know about etiquette in the courtroom, and I can't imagine that anybody who's attending this particular seminar or presentation would be like this, but if there's a comment made, even to court staff, that appears to be biased in terms of gender, sexuality, race, or ethnicity, a judge actually has a duty, an ethical duty, to call out the attorney on that behavior and to say that kind of behavior, that kind of comment will not be tolerated in this courtroom. So even the innocuous comments about what people are wearing, if a court staff member is offended and it comes to the judge's attention, the judge has a duty to talk to that attorney. And of course, if it comes to any kind of racial or ethnic overtones, the same thing applies. Judges have an ethical obligation to counsel the attorney about that type of behavior. Now, like I said, you're at this presentation, you are almost certainly not the attorneys who are going to say things like that. But unfortunately, even in 2020, there are attorneys out there who will say things like that to court staff, sometimes even to judges. And it's not okay. Another thing in terms of etiquette in the courtroom, please, you get more with honey than you do with vinegar, if you know the old saying. And being belligerent and rude and disrespectful to opposing counsel is not the way to do things. First of all, the opposing counsel is going to dig in his or her heels, and you're not going to get any accommodation there. But the judge is also not going to appreciate it. So that's about etiquette in the courtroom. Now I want to move on to more of the serious stuff. One of the things in your handout is Formal Opinion 74. So let me explain that. Ever since 2013, maybe the beginning of 2014, I have been a member of the California Judges Association's Ethics Committee. The Ethics Committee has a hotline that is available to all judicial officers in the state of California. And we take inquiries from judicial officers, which include, by the way, certain hearing officers, Court of Appeals justices, certainly all trial court judges, commissioners, on issues involving ethics. The ethics committee does everything confidentially, and we respond in writing to an inquiring judicial officer's questions. We do that all the time. In addition to those individual inquiries, most years we write and then publish for the judiciary formal opinions on issues that are of general concern to judicial officers around the state. This year, we haven't done a whole lot because of COVID-19. We did one formal opinion did come out at the beginning of the year on judicial officers and the uses of social media. But for the most part, we usually issue 2 or 3 formal opinions a year. And opinion 74 was published, I think, about 2 years ago. And it is on the topic of what types of conduct engaged in by attorneys do judges have to report attorneys to the state bar on. And so you can take a look at that. I'm going to go over some of the scenarios, but by no means am I going to go over that in great length. But there are 2 statutes that are very important for you as attorneys to be aware of, not only to monitor your own conduct, but to also be aware that these 2 statutes mandate judicial reporting of conduct. That's Business and Professions Code, sections 6086.7 and 6086.8. Section 60866.7 mandates that a judge must notify the state bar of the following types of conduct. If the judge either is the judge who makes the final order of contempt against an attorney or becomes aware of a final judgment of attempt against an attorney, that fact, the contempt finding, is requires mandatory reporting to the state bar. And that's probably not as common as certain other things, but one of the things that you should be aware of as practicing attorneys is if a matter goes up on appeal and is reversed or modified in whole or in part based on the misconduct, incompetence, or willful misrepresentation of an attorney, the trial judge is required to report that attorney to the state bar. If a judge imposes judicial sanctions over $1,000, again, the judge is required to report that to the state bar. If in a criminal case, the trial court finds that a prosecutor acted in bad faith, which contributed to the guilty verdict or a guilty no contest plea by a defendant, that too requires mandatory state bar reporting. And then there is, if there's an imposition of civil penalty under Family Code Section 8620, which most of you probably won't have to deal with, but that has to do with falsifying a child's Indian heritage, one way or the other, falsifying one way or the other. If a judge ever imposes a civil penalty on an attorney for such falsification, that requires mandatory state bar reporting. Under Section 6086.8, if a judge, let me step back. Under that section, a judge is required to report to the state bar within 20 days of a judgment if there is a finding by court or jury that an attorney is liable for damages in a civil action for fraud, misrepresentation, breach of fiduciary duty, or gross negligence committed in a professional capacity, we are required to report that to the state bar. And let me step back for a second. I do not think I am alone in feeling this way, but I will do anything to not report an attorney to the state bar. I loathe it, and I would hazard a guess that most judges don't want to do that. But we are required under those particular situations that I've just indicated to do it. We are also required to notify the attorney before we do it that we're doing it. There are some other areas that I wanted to talk about that are scenarios listed in Opinion 74, where a judge may be required to report an attorney to the state bar. If an attorney is suspended from practicing law, even for a temporary period of time, or has resigned from the state bar for whatever reason, and dares to make a court appearance, that is a no-no. And a judge has to report that to the state bar. I know of a case in this county several years ago where an attorney was suspended for failing to pay state bar dues and apparently did not realize that he was suspended. And he made court appearances, and then he learned he was suspended. But that requires reporting to the state bar. In that particular case, he paid his fees right away, and it was fine. But just be aware. Then here are some other situations where a judge has to take corrective action, which does not mean reporting to the state bar necessarily, but it requires the judge to do something. So I'm using scenario 11 in Opinion 74, and this particular example was a deputy public defender, but it could be any attorney. And by the way, let me also explain that in Opinion 74, these scenarios, each one of these scenarios were taken from inquiries by judicial officers that came to the ethics committee. So these are real life situations. These are not things that we just made up for the purposes of writing this opinion. So in that case, a deputy public defender was consistently late and unprepared and seemed to have a poor relationship with his clients. And the question was, does the judge have to do something? Yes, the judge has to do something. The judge has to take some corrective action, which in that situation would most certainly involve either talking personally to the attorney or to the attorney's supervisor. It is absolutely not something required to be reported to the state bar, but it is something that a judge needs to try to correct. Another situation in scenario 13 was where a judge learned that an attorney is terminally ill, and the terminal illness had very obviously affected the attorney's ability to effectively represent his clients. Again, the judge has a duty to at least try and talk to the attorney. If that doesn't work, then may have to report that attorney to the state bar. Number 15 in this opinion dealt with a DA, a deputy DA, who is routinely rude and discourteous to administrative and courtroom personnel. And this is something that I mentioned earlier. A judge is required to take corrective action, which may include either talking personally to that attorney or going to the attorney's supervisor. But a judge cannot allow attorneys to be rude, discourteous, or to make offensive comments. The judge cannot. That's something that maybe I should explain. One of the canons of judicial ethics that we judicial officers all have to follow involves that a judge must be patient, courteous, dignified, not exhibit bias to attorneys, litigants, anyone who comes in front of it into that judge's courtroom. A corollary of that duty is that we have a duty to make sure that everybody who comes into our courtroom also abides by that same ethical rule. That's why you will see that we have to take corrective action when an attorney is being rude, disrespectful, or offensive. Number 21 in the opinion has to do with a new trial motion. So Business and Professions Code 6086.7 tells us that a judge is required to report to the state bar if a conviction, actually it's not just a conviction, if any case is modified or reversed on appeal based on incompetence, willful misconduct, or willful misrepresentation. But when it's still in the trial court, if there's a motion for new trial by one side, and in the course of ruling on that motion for a new trial, the judge determines that one side or the other was either incompetent, or in this scenario in the opinion, it was a prosecuting attorney who intentionally withheld evidence. The judge has a duty to report that conduct to the state bar. If the judge grants the motion for new trial based on the misconduct or the incompetence. So you all need to understand that the judges have mandates. They have the canons of judicial ethics which govern our own behavior, which also, to a certain extent, requires us to control the conduct and behavior of anyone who comes into our courtroom. We don't want to report people to the state bar, and hopefully none of you will be in that situation. But independent of the judge's responsibilities, you all know that you have to follow the professional rules of responsibility. And what I have said this evening is nothing different than what you already know that you have to comply with. And I know this is like maybe the heavy-handed part of this whole presentation, like reporting attorneys to the state bar. That's not the point of what I'm saying here. The point is just to let you know that what you say and do in court matters. What you say and do in court affects everyone. It affects your clients, it affects court staff, it affects the judges, and when it crosses a line, a judge has to take corrective action. Most of the time, the corrective action is going to involve taking you aside, talking to you, pointing out the comments or the conduct, and telling you not to do it again. But sometimes it goes so far over the line that the judge has to report it to the state bar, and you just need to know that. Thank you.
All right, we're going to transition now to Judge George. She's going to begin dissecting Rambo litigation tactics.
Okay, thank you, Craig. Good evening, everyone. It's nice to see your names on the attendee list today. Thank you for coming. I kind of want to take up where Judge Mockler left off and start with something she also mentioned, which is, I can't underscore enough. Tomorrow, by the way, this is an aside, I will have been sworn in as a lawyer, even though I'm not a lawyer anymore. Tomorrow will be my 34th anniversary of being sworn in as a lawyer, June 10th, 1986. So this is kind of on the eve of my 34th anniversary. So I feel kind of especially honored to talk to everyone tonight during such an important time for me. But to go back to what Judge Mockler was saying a moment ago, I can't stress this enough. Word gets around. Judges talk, attorneys talk, court staff talks. If you are a reputable, honest, straightforward, straight shooting attorney, your reputation will precede you and will stay with you, hopefully. If you are not, that reputation stays with you and will precede you. I'll get back to that in just a second. Secondly, I'd like to give you a quote from someone who I respect a great deal, former President John F. Kennedy. And he mentioned, civility is not a sign of weakness. I read that and I let that sink in. Civility is not a sign of weakness. We all go into court, we want to win, we want to show our client that we're, the best attorney in the room. We want to make sure that the judge knows we know our stuff. But you don't have to be aggressive and you don't have to be overly bullying or rude to get there. Finally, before I get into some of the dissection of the Rambo litigation tactics, and I noticed there's a couple of my former law students out there in the crowd tonight, so hi, shout out to you guys. I used to say this to them all the time when I taught at JFK, and that is, and they know what I'm about to say, your reputation is like gold. Your reputation as a lawyer is like gold. Cultivate it, grow it, and protect it. Never underestimate how important your reputation is. Because if you ever lose it or you ever do something that makes it tarnish, you probably won't get back to where you were. And that comes from many examples I've seen over the now decades that I've been in the law. So, keeping those quotations and thoughts in mind, I want to dissect Rambo litigation tactics a little bit. I didn't think of that term. That term was in some of the materials that I reviewed and that you actually have, that you'll get, or you already have tonight. A person by the name of R. Sayler, S-A-Y-L-E-R, wrote an article for the ABA Journal back in 1988, and the article was called Rambo Litigation, Why Hardball Tactics Don't Work. And in that article, the author described 5 components of what the author thought were Rambo litigation. I think we all know who Rambo is the character in the movies, but that person had a reputation for being very cutthroat, surviving, getting through some horrible situations. There's a whole big thing there, but we won't go into it. But suffice it to say, I think almost everybody here has heard of Rambo. The first Rambo tactic that was discussed in this article was, one, a Rambo litigation tactic is a conviction that it is invariably in your interest to make life as miserable as possible for your opponent. Doesn't matter whether you win or lose, just make her, him, them really hate the day you walked into that courtroom. Number two, Rambo litigation tactics have a disdain for common courtesy and civility and presume that those are the most appropriate characteristics for a true attorney. Number three, Rambo litigation tactics involve a wondrous facility for manipulating the facts and engaging in revisionist history where facts are concerned. Number four, they also have a hair-trigger willingness to fire off unnecessary motions and to use discovery for intimidation rather than fact-finding. Now, most of the civil attorneys, probate attorneys, litigation attorneys are very well versed in discovery tactics. And as a former DA, as a former civil litigator, and now as a judge, we know when someone's really using those tools appropriately and effectively, and when they're simply just using them for other purposes, to badger, to run up fees, to make things miserable. Finally, the final Rambo litigation tactic is an urge to put the trial lawyer on center stage rather than keep his client or his cause or her client at issue. The ABA rules in their model professional conduct rules state a lawyer can be tough and aggressive and still not be obnoxious and rude. Civility does not suggest weakness or a lack of zealous representation. A lawyer's duty is to act with reasonable diligence and does not require the use of offensive tactics or preclude the treating of all persons involved in the legal process with courtesy and respect. I think for whatever reason it got out there, maybe that's just the way it is for lawyers, it got out there that the more rude, the more aggressive, the more uncooperative, the more just out and out rude you are, the better you are as an attorney. I've seen that. I've actually done that a couple times back in the day. It didn't pay off, I'll tell you. I've seen a lot of my former colleagues in the DA's office do that. And sometimes it was great, most of the time it wasn't. It only really worked when that was who the person truly was, and even then, it didn't go too far. Incivility can take a lot of forms. I know the people, as Judge Mockler said, that are here are probably just going, yeah, I've seen that, yeah, I've seen that, yeah, I've seen that. But it's really important to be aware of it and to, frankly, I think, call people out on it. So that can be refusing to grant an extension to accommodate opposing counsel's vacation, unsolicited attacks in meet and confer letters, insults during depositions. How many of us have seen, endless deposition tapes where, frankly, attorneys either come to blows or are cussing each other out like truck drivers or both? All the while, there's a witness or a client or everybody sitting there. And like I said, some lawyers think that these tactics demonstrate zealous advocacy, but there's a tipping point. There's a tipping point where you can be an effective, strong, professional person and then tip the scale and become the jackass, excuse my language. Bad behavior becomes acceptable to that attorney, and then the client sees that for those private attorneys out there. Excuse me. But what it does do, to echo what Judge Mockler just said a moment ago, it can anger a judge, It can end up costing your client fees. It can lead to unnecessary quarrels. And frankly, it will heighten your stress and make your profession less enjoyable than it already could be. One more time, it weakens your professional reputation beyond belief. And you don't have to be a judge to know when somebody comes into a courtroom, or when you pick up a pleading, or when you look at somebody who's writing you a letter, an email, or a letter that comes in the mail, you go, oh, it's her, here we go, or him, whatever. You just know. And unfortunately, even early on when we're first practicing, those reputations can stick. Apparently, there's a lot of examples of this. I know we've all seen them, but in a particular case, Crawford versus JP Morgan Chase Bank, the 2015 case, one lawyer during a deposition was so mad at opposing counsel, he took out pepper spray and started spraying it about. And then when that didn't work, he took out a taser and thought he'd try his hand at the taser. That went in front of a judge, of course, at a later date. The judge started to reprimand that attorney at the hearing, and then that same attorney started to insult the judge by cussing at him. Well, in upholding the sanctions order on that case, the Court of Appeals stated, quote, far from the trial court abusing its discretion, it would have been an abuse of discretion not to impose a sanction. So these types of behaviors negatively impact everybody, as again, to reiterate what Judge Mockler stated. It negatively impacts the judge's view of the lawyer. It hurts the client's position. And while many clients think it's kind of cool to have an aggressive lawyer that's going out there and pounding the other guy into the ground, or girl into the ground, it's a tipping point, because at some point you risk the client disliking you, maybe disengaging you, the judge disliking you, maybe not wanting to hear what you have to say any further. And by the way, many times during my career, I was very cognizant of not making the judge angry. There are many times I also didn't agree with the judge. But there has to be a way that in our own styles that we are able to convey to the judge, I hear you, Judge, but may I please disagree with you, or may I please state this? There's a way you can disagree with the judge without making them too angry. When I was back at USF doing my first moot court, Judge Ira Brown, who was one of the most revered, I guess that's the best word to use, judges in San Francisco County Superior Court, was our trial judge. And he was interrupting us all the time. We were putting on our cases. He was interrupting us. And I was up at the podium addressing an issue, and he asked me a question, and I thought I answered it. And then there was just silence. And I said, if I may continue. And for whatever reason, that made him mad, because apparently he had just taken a breath to continue on. And I think it was a little bit for effect too, because it was moot court. He took his pencil and he snapped it. And from that day on, I never used that term, if I may continue. I also, and for whatever reason, we learn things as we go through. I want to fast forward to some helpful tips that might hopefully resonate with all of us in maintaining and cultivating civility in the courtroom. And to quote Justice Sandra Day O'Connor, she stated, more civility and greater professionalism can only enhance the pleasure lawyers find in practice, increase the effectiveness of our system of justice, and improve the public's perception of lawyers. Practicing law is simply more fun and less stressful when we even have a modicum of good rapport with opposing counsel. As one court of appeal put it, and this is a little dated now because we're in COVID times, but I'll quote it, quote, the handshake at the end of the trial is not the only time when professionalism and civility are expected. A very decent person who was a deputy DA, she's now retired, a good friend of mine, she was in a homicide trial, very nasty, ugly trial against an incredibly good private attorney. The entire trial, they were professional, they were courteous, they fought the fight, but they always were courteous and civil to not just to each other, but to the judge. And the judge was Judge McGrath, who is no longer with us, but he was a very civil, wonderful man. At the end of the trial, the deputy DA came up to me and she said, you know, she got the verdict that she thought she would get. But she said, you know, the jury came back to both of us at the end of the trial and said, we so appreciated the fact that the two of you, even though you differed so much in your views, were civil and respectful to each other. And some of those jurors had been on previous juries. She was blown away by the fact that the jury brought that up to them at the end of the trial, that they recognized it and they noted it and they stated it to counsel. So don't think that people aren't watching, particularly juries. I'm going to quickly jump to a couple of points on maintaining and cultivating civility, and then we'll go to the next part of our discussion. First of all, how do we avoid conduct that may end up being damaging to the profession, to our clients, and to our reputations? I know Matt's going to talk about this little, so I'm not going to talk too much right now. But first and foremost, get a mentor. Get a mentor. Get someone who you look up to, who you've heard about. Maybe you may not even know them. Talk to them. Contact them. Ask them for their recommendations, for their guidance, for their advice. You don't have to have one person. You can have more than one. You can have more than one mentor. I did, and it helped me significantly. We'll talk about that in a minute. 2, accept the premise that civility is good and incivility is bad, no matter how tough it gets. And it can get tough. Believe me, I know. 3, follow the golden rule. I know it sounds really corny and goofy and almost grade schoolish, but treat others the way you would want them to treat you. Don't intentionally mispronounce their names to get under their skin. Don't hide evidence under a book and say, oh, I thought it was here. You know, all those goofy tactics that you hear about or see other people do, don't do that. You wouldn't want it being done to you, don't do it. And it's, sometimes you may want to do it because you're kind of mad, but don't do that. Fourthly, I can't stress this enough. Become involved in local bar associations and bar-related activities. As we become better acquainted with our peers, members in our profession, we realize that our professional reputation really does matter. That's where it's underscored. Not only of how good or how smart we are, but completely how we treat each other, particularly in these days. Sitting on a board or a bar committee, particularly if it's with an opposing counsel, that will get you to see a whole different side of them. Be able to recognize that maybe they're not as bad as you thought after all. And believe it or not, and I've had that opportunity too, it's different when you see them in court the next time. It's just different. From personal experience, when I was in the DA's office, there was a public defender who, she and I just went, we were, you know, at war every time we went to trial. It was just war extravaganza. And time went by and you get older, way older. And she ended up leaving criminal law and going into probate law. And for the last 15 years, maybe a little more, she and I have been on cases together. We've been opposing counsel. I've mediated her cases. I got to know her as a friend, and she's now one of my best friends. And we look back on those days and we go, hey, remember that? Remember that? It's kind of funny to look back now, and it's almost like you've grown up out of a sandbox in a way. But things change, and it's a good thing. This is an important one. As best as you can, avoid personal attacks. You can tell that you disagree with opposing counsel without attacking him or her personally. But you can't use words like ridiculous or ludicrous or stupid. You know, just try to not do that stuff. It's like throwing gas on a fire, as you all know. This is a hard one too. It's really easy to say this. Treat every email as if it were a formal letter. By that, use written communications that aren't abbreviated, aren't snitty. Just use use email as if it was a letter, if you do. My preference actually is to try not to get into email back and forth. Use it, you know, attach an attachment of a letter that's professionally written, but don't get into the email war, which is corollary number 7. Do not send emails when you are angry. I've seen it. I haven't done it, thankfully, at least as far as I know. I've seen it, and it just goes downhill fast. And guess what? Not only is it bad, opposing counsel now has a record of you acting like a jackass and can attach it as an exhibit to something that he or she thinks the judge should read. Which leads me to the next one. Assume all correspondence with opposing counsel will end up in front of a judge and will be carefully read by that judge. Also assume that the judge will not be impressed by your repeated accusations of unethical and other untoward conduct by opposing counsel. Almost one more and then we're done. 9, do not let an uncivil lawyer drag you into the mud. It is tempting, but don't let them drag you into the mud. Stay above it. I mean, you know what your buttons are when they can be pushed, and good counsel, good opposing counsel can figure out what your buttons are. If they've known you or if they figure it out during trial, don't let it happen. Fight it as best as you can, because it's going to be on the record and it's going to be there forever. Here's my favorite, and this is what I'll end up with. I'll end my part with. Finally, pretend that your mother is present at all of your depositions. Pretend your mom is sitting right next to you. No matter what you say or do, your mom is going to see it, hear it, and watch it, no matter what you say and do. The goal of a deposition should be to gather information, not to make the next 7 hours of a witness and his counsel's life living hell. I'm going to close with this, and then I'll turn it back to Craig. The law is a noble profession. There simply is no place in it for what I was talking about, Rambo litigation tactics. And Justice Reichman of the First Appellate District recently stated in an opinion upholding a sanctions award, and I'm going to quote him right now. We close this discussion with a reminder to counsel, all counsel, regardless of practice, regardless of age, that zealous advocacy does not equate with attack dog or scorched earth, nor does it mean lack of civility. Zeal and vigor in the representation of clients are commendable. So are civility, courtesy, and cooperation. They are not mutually exclusive. So with that, I will turn the mic back to Craig and go to the next phase of our discussion. Thank you. I think you're on mute, Craig.
You are on mute.
Unmutify.
See if I can.
David, can you help?
I think we're going to Matt and Judge George anyway. So why don't you just take
Okay.
it away?
Matt, I'm going to let you start so I can get a drink of water.
I'm
You
back.
bet.
Oh, there they
Um,
are.
Thank you, Ann. I was not able to unmute myself. So I just, before we go into the next section, as some of you know, I started my practice in LA and Orange County. And it's interesting to note that when you add the LA County attorneys, the number of practicing attorneys, to the Orange County attorneys in San Diego, those 3 counties, you have half of the practicing attorneys in the state of California. And I've talked to a lot of attorneys who have practices where we still practice in LA courts, and we have a theory that there is just so many attorneys there that there's a sense that they'll be anonymous. There's a sense that maybe you can get a good reputation, but there's too many. I'll never see this one again. I'll never get a bad reputation. I find the opposite is true. I've found people can get a bad reputation no matter how large community, and it happens now because of technology. I don't have to call. I can email. I can go on a discussion board, and I can find out somebody's reputation very quickly. I'm not going to take much time with LA stories, but now that I'm up here and I've seen a very different way of practice, I tend to use the LA tactic or the Rambo tactic. Not personally. What I'll do is I'll talk to a lawyer about my history and the fact that I've moved up here and how different and collegial the practice is, and that I don't expect them to follow. And of course, they'll say, well, why would you expect that? And I'll say, because of where you're from. I think you're more likely to, but I'll make an agreement that I'll only call them out for Rambo tactics if they pursue them. Of course, they sometimes do and sometimes don't, but I've got a basis for calling them out. And I agree with Judge George. It's time to call them out when we do see it. I want to take a half step back, and hopefully Judge Mockler is not muted, because we did get a question. We got a quick question that hopefully has a quick answer. The question from one of the attendees was, there's sanctions in excess of $1,000. How does one know if the judge has reported it to the state bar?
The answer to that is the judge is required to tell the attorney that the judge is reporting the attorney to the state bar. So that's how you would know. There are clearly judges out there who've imposed sanctions of $1,000 or more who have not reported you, not you, whoever asked the question, but who have not reported the attorney. So the judge has an ethical duty to inform the attorney before reporting to the state bar. Hopefully that answers the question.
So how does opposing counsel know, is the question from the audience.
Oh, how's the opposing counsel know? I don't know that they necessarily would, because it's not something that the judge can share with opposing counsel. So that's all I can say about that.
They may not know. All right. We're going to move to the next section in our presentation regarding reputation with your supporting personnel, etc.
So, Matt, do you want to start it off? Or
well, I'll start it off, but perhaps I'll finish it off considering what you already said about earlier. And it absolutely goes without saying that when you show up in court or when you're dealing with your own support staff or the support staff of opposing counsel, that you exercise what I call professionalism, ethics, and civility. And I always like to say civility is not a bad word. It's a very good word. It doesn't show weakness. It actually shows strength. And I've done a fair amount of mentoring when I was in the district attorney's office, and then running the office of a big firm, and now with my little firm. And I often tell people that when somebody on the other side says something to you and you're trying to make a point, just simply move your head to the side and let it go right on by and get back to the focus of what you're talking about. That often throws people off. People who perhaps use Rambo tactics to try to throw you off. I don't let it throw me off. What I like to say is, it is unhelpful to your client, it is unhelpful to your case when you are unethical, when you're not prepared, when you're unprofessional. And it just goes without saying. I recall when I first started in the district attorney's office in Martinez, and I was told we were mentored. We had mentors constantly. In fact, I learned so much sitting at LeBeau's or various places about ethics, about the how law should be practiced, and getting mentored. And the idea is be professional. be prepared. And I can't stress that enough. When you're new, when you're young, you come in, make sure you know your case, know your facts.
We may have lost Matt Guichard for now.
Wow.
Welcome to Zoom.
Yeah, I told you guys.
Welcome to Zoom. Well,
Zoom is not
I
the
don't know
greatest.
if Matt's gone for a minute, I'll take up with my part until he rejoins us.
Please.
All right. So one thing I wanted to mention,
I call you back.
are you back, Matt?
I'm here. So I have
Okay,
a
forget that.
trying to call me my iPad. Thank you very much. So at any rate, it's not helpful. And I always tell people, we are a nation of laws. We have a complex system of laws, and we as lawyers are very important cogs in that. Clients rely on us, their business disputes, their legitimate disputes. Prepare yourself properly, argue properly, in front of a judge, argue properly. And one thing I always like to say is, in front of a judge, and I'm not a judge, but I've been through many programs where judges say, make your point at the start. Don't start out with, well, Your Honor, I'm here just because the guy on the other side is kind of a jerk and he had, no, judges don't want to hear that. Jurors don't want to hear that. They don't like to see fighting. They like to see civility. So I think it's very important. I think we've probably beaten this one into the ground about being nice to court staff and staff. In all cases, if counsel calls me and says, I need an extra 2 weeks to provide responses, I always give it to them, even if they have not given it to me at least one time, because I think that's professional and that is the appropriate thing to do. So at any rate, that's all I really have to say about the reputation. When I hit Martinez, as I said, perhaps you missed, judges talk, staff talks, and it goes like lightning through the courthouse when an attorney is, I'll use the term, a jackass. It also goes like lightning through the courthouse when somebody comes in new, very well prepared, very professional, and makes a cogent argument, win, lose, or draw. So its reputation is so incredibly important. And for those of us in these times, for many who are looking for a job, thinking that perhaps my firm is going out of business or whatever, that reputation is going to follow you. And people are going to find out that, nah, that lawyer is not a nice person, doesn't come well prepared, not going to hire him. So please do not engage in that kind of conduct, please.
And just to kind of piggyback on that, Matt, think of like your reputation like gum. It sticks to you. It can be a very good thing. As time goes by, it burnishes. It gets really great. It's polished. You walk in and, people are respectful. It grows and it's really a treasure. But you can tell when people just don't care. They don't care, or they think it's better for them to be Rambo-like than not. One last thing, then we'll move over to the mentoring part of this. The people that I know that are the people that I respect the most, my mentors and the people that came after me that I think have a real great chance at doing wonderfully in the profession, are people who engage. They engage in their community. They engage in their trials. They engage in their cases. They're sincere. They're not trying to hide the ball. They want to get to it and get out. If you know your trial's going to go to trial, then just move ahead. Move ahead. And, the best that you can do. Don't delay it to get a bunch of money. I mean, I know these are really simple things to say, but that stuff sticks to you. And the more you are prepared, the more you know your evidence code, the more you listen to what the judge instructs you. When you object and do a speaking objection, and Judge Mockler says, Mr. Nevin, we don't allow speaking objections in this courtroom. Okay, thanks, Your Honor. Next objection. Objection, Your Honor. This man over here was talking, and that's not acceptable. And especially when there's a jury there. Judge Mockler is going to call Mr. Nevin and opposing counsel to the bench and say, I've given you one warning. This is your last warning, Mr. Nevin, please, or worse. So listen to what the judge says. You may disagree with it, but that's the judge. Respect the robe. You don't necessarily like the person or want to be around the person, but you have to respect the robe. Matt, do you want to take over with ins of court and mentoring, et cetera?
Yeah, I'm happy to. So I like to say I was there almost at the inception, not with Judge Marciano and Judge Minnie when they put together our Inn of Court, which wasn't named the Robert G. McGrath American Inn of Court initially. It was just an American Inn of Court. But so aptly named for Judge McGrath, I used to appear in front of him and talk about civility, always kind, always professional. And it was just wonderful to appear in front of him. And he always let litigants, particularly people that were in pro per, have their say. And I always felt that, goodness, that man has a great deal of patience, perhaps more patience than I could ever have. What I want to do is, I've always pushed, I think I was the president of the Inns of Court at the 10-year anniversary, and not too long ago, we finally had our 20-year anniversary of the Robert G. McGrath American Inn of Court. And its foundation is based on ethics, professionalism, civility. And interestingly enough, today in these times of ours, the president of the American Inns of Court, the national president, sent out a missive to colleagues and talking about how the American Inns of Court was founded 40 years ago and how we envision a legal profession and judiciary dedicated to professionalism, ethics, civility, and excellence. And every lawyer should aspire to that. I have always pushed for people in our community to join the Inns of Court, get on the waiting list if there's a long list. There used to be, I'm not sure now, I don't know. But the mentoring that goes on with that, and just as George says, Judge Mockler, you're sitting down to dinner at times or in a meeting next to the judge that you may be appearing in front of the next day or appeared in front of a couple of days before. So you get to know people on a human level. And the last thing you want to do is go in front of that same judge and be a jerk. Again, I'll go back and say, it's unhelpful. It's a word that I like. It's unhelpful. It's unhelpful to you and your reputation. But most importantly, you represent a client, and it's unhelpful to your client. Can anyone think that being a Rambo lawyer is helpful to the client? At the end of the day, it's not. Jurors don't like Rambo lawyers. They don't like fighting in the courtroom. Judges don't like it. I personally don't like it. And I put it kind of in the back of my head. Okay, next time this guy comes up, I'm going to remember that. And I'll be as courteous as I can. But reputation is so critically important. As Judge George said, I want to say how important mentoring is. And I read all these articles. It's something that has kind of fallen by the wayside, and it's something that we need to encourage to mentor people. And so often we have in our system, you can graduate from law school, you can pass the bar and put out your shingle and be a solo. Nothing wrong with solos. There are lots of them now. But in many cases, there isn't the kind of mentoring that we need to encourage. I practiced for some time in Europe, in both in Austria and in Denmark. You don't get to practice law until you have been mentored and worked for somebody for a period of 2 years in both Austria and in Denmark. And that mentoring, that this is how you operate. And I want to say about mentoring something I often say. We've become cowards in the sense that it's something that we wouldn't say in public to somebody face to face, but we say it in an email because they're not there. And I often tell people, and this is part of the mentoring, if you are angry and you write that angry email, don't hit send. Sleep on it, look at that same email the next day and say to yourself, whoa, is that something I want to send? And I will bet that in many cases, because I've done that, in many cases, oh boy, I'm sure glad I didn't send that email. So think about those kinds of things. It's unhelpful to do that kind of have that kind of behavior.
Let's try to catch up on a few more questions from the audience. The first two are judges. When you are faced with ambo tactic, how do you recommend a responsive communication that is above the bar, but also protect your client if this is pursued by other counsel?
Judge Mockler?
I will, in my view, opposing counsel should just ignore it. Just continue on, make your points, make your argument, just ignore it. That's what I've seen to be the best tactic, because the counsel who is making some personal attack, they want to push buttons. But if you don't take the bait, it's not going to go anywhere.
I agree. I think the worst thing you can do would be to try to either one-up them, which you shouldn't, or somehow respond. The worst thing you can do is to start a banter, because then it just goes nowhere fast. So I agree. I think just saying nothing and just keep on point. Don't get into the mud with them if you can help it.
Okay, let's go to interesting question. Another question to the judges. Given the close community in which we practice, under what circumstances do you think it's appropriate to pursue a motion for contempt or sanctions? Does your view differ between discovery motions with other orders? Do you have any tips for how we can present motions for contempt or sanctions but still maintain a civil demeanor?
Well, I'll go ahead on the first part. Every case is so different. I mean, do I hear motions for contempt? Yes. Do I issue sanctions? Yes. I try not to, but it's kind of the last resort. But in answer to your question, if you are going to file a motion for contempt or sanctions, just hit it as straight down the line as you can. I mean, cite facts. Don't start the banter. Don't start the names. Don't start just talk about something that happened on the record. Talk about something that's on a transcript that you can show, and just keep it as smooth as you can. Because then if you don't, then it gets into a back and forth, and then we lose the truth in the middle of it. Judge Mockler?
Well, I've probably had less experience with contempts against attorneys than Judge George has had. Because most of my career as a judge, I was in criminal or 4 years in family. And in criminal, nobody filed that kind of thing. And in family, it was generally filed by an attorney against a litigant. And in family law contempts, they're actually misdemeanors and treated just like a criminal case would be. So you're unlikely to get a contempt out of family law because of the beyond a reasonable doubt standard on a family law contempt.
We have another question. It's a two-part question, I think. First, how do we deal with the judge misunderstanding what we're saying in argument? Part two, how about a judge who gives advice to opposing counsel under the guise of case management, such as a judge pointing to a defense-friendly code provision?
Well, just to jump in on that, that's a case-by-case thing. As far as the misunderstanding, it's kind of like with me and Judge Brown back in the day. I didn't know that bothered him when I said, if I may continue. But you get signals. Some are more direct than others, and just try to redirect, try to change tact. I angered a judge once, I didn't even know it, by talking about something, how a case progresses through the criminal process, and we were in a civil department, not in this county. And that judge got really mad, and I thought I was just explaining it to her, you know, here's how it works. And I guess in hindsight, she probably thought I was calling her dumb or something. But at any rate, if something comes out of the blue like that, you just have to learn to shift and pivot and take another tactic. It's too, there's too many ways that can happen, but that would be my general answer to that. Try not to get upset if you can, because a lot of times the judge is just saying something or doing something off the cuff and not even thinking about it. Judge Mockler?
Well, there's two things in that question. One, as to a judge misunderstanding your argument. Do not assume that that's what's going on. A judge may simply disagree with your interpretation of the facts or the law, and that's not the same thing as misunderstanding your argument. Secondly, if a judge is, in counsel's view, helping the other side too much, mention it once. Oftentimes, that is enough to get the judge to think, oh, you know, maybe I've become a little bit too much of an advocate here. Let me step back. If it doesn't help, you've made your record. And then, as Judge George said, you have to pivot and try a different angle.
Yeah, I want to say a little something about that. I'm quite a fan of the complex litigation departments that we have in most counties and here in Contra Costa County and in federal court, because I've always been a fan. Unfortunately, in our regular civil departments, there isn't time to spend with each case that we do in complex and in federal. But in federal, the judges, I'm not talking about at trial, I'm talking about when you're initially appearing in front of them and these very lengthy case management conferences where there really is a discussion and there really is a sense of, all right, you want to take 15 depositions. What I think you should take is these 3, and then we'll come back in 60 days and have some discussion about that. So there's a lot of kind of helping, and the judges are actually expressing their opinions about how the litigation should go and how it should be performed. So I'm not sure the question was at trial if a judge is bending over backwards, but I really wish that every judge had the time to really sit down and, I call it mentoring, but it really is a discussion of the case and how that case should proceed. And I think litigants find it very helpful when somebody thinks, I need 20 depositions, I need all this discovery, and the court will say, well, why don't we take 4 depositions, and why don't you initially do this paper discovery, and we'll come back in 60 days and see where we're at. And I find that to be very helpful.
Very good. Very good. So let's move on to Judge Mockler's and my section about Yelp and Avvo reviews. How can, but should you respond?
All right, well, I found this to be a fascinating area to do a little research on. First of all, I have to say, having been a public defender my entire career before I was appointed to the bench, I didn't really have to deal with this aspect of things because, well, for one thing, Yelp and Avvo reviews weren't as prevalent when I was practicing. And for another thing, they are used a little less for public attorneys than they are for private attorneys. But there actually are some ethical opinions out there. Some of the larger counties have ethics committees as part of their bar associations. So San Francisco and LA bar associations actually have ethics committees as part of their bar association. And both of them have published opinions one in 2013 that was out of LA County, and one in 2014 out of San Francisco County, dealing with specifically this issue on ethical duties of lawyers regarding adverse comments by former clients, sorry about that. So the San Francisco ethics opinion is a formal opinion number 525 from 2013. I'm sorry, I said San Francisco. That was LA County. And the 2014 one is from the Bar Association of San Francisco. In both cases, the issue was how, if at all, should attorneys respond to public comments that, by former clients that are negative. And some rules there are actually out there. First of all, you cannot disclose any confidential information that hasn't already been disclosed by the former client. You also, in your response, can't injure the former client, and your response has to be proportionate and restrained. That's the gist of both of these ethical opinions. The first question, of course, to ask yourself is, should you respond to a negative AVO or Yelp review? And I have to say, when I was first doing research on this topic, I was thinking to myself, I was thinking like a judge, because judges do get bashed online. And from a judge's standpoint, unless it constitutes a threat to court security or the judge's security, we're ethically supposed to just ignore it. But for attorneys, these reviews are also marketing strategies. And so from an attorney standpoint, you may want to try to do something about a negative Yelp or AVO review. So question number one is, should you respond at all? If you decide that the comment, the public comment, is so far off base and is injurious to your practice, then you can respond, keeping in mind that, first of all, if there's still pending litigation with that client, don't respond. If the litigation is over, then you have to make sure that you don't disclose any confidential information, you don't injure the client, and that your response is proportionate to the review and restrained. The other thing that you can do is you can see if you can ask AVO in particular. There is a dispute resolution process. You can ask that AVO put the review through a dispute process. You can also post your own response to the review, countering whatever the former client has said. Again, not disclosing confidential information and being very restrained. In terms of Yelp reviews, I found an interesting article online by, on a website called Cooper.com, COOPER.com. And it's a whole article on how to respond to negative Yelp reviews. It has some do's and don'ts. The do's are address the user by name, include key details, do your own research, be sure you know what they're talking about, show understanding and end on a positive note. The don'ts kind of are commonsensical. Do not get defensive. Don't take things personally. And don't attack the reviewer. With regards to what you actually say, you should restate the actual problem that's been complained about. Stick to the information presented in the poster's review. And to keep in mind that you are not trying to change the reviewer's mind. The reviewer has this opinion that you did a crappy job for him or her in representing that person, and you're not going to change that. So the only reason really to respond is for the purposes of marketing in the future, so that other people who might be prospective clients of yours don't think that this is the way you do business all the time. And finally, the recommendation is that if you do decide to post a review disputing what your former client has said, post it and leave it. If the former client decides to respond, it's just like this email chain we've been talking about. Stop. You've done your job for marketing purposes. You've put out the facts that weren't what the former client stated, and then you move on. But for anybody who's interested in this area, I highly recommend that you read LA County's 2013 Formal Opinion number 525 and San Francisco County Bar Association's Opinion 2014-1. It gives you a very good description and explanation of your ethical obligations. Some of the I don't think much of the rules of professional responsibility have changed. I double checked that before talking today, even though there has been a change in the numbering and the rules of professional responsibility, does not affect the substance of those two decisions. But that's all I have to say.
All right.
Craig?
Can I jump in real quickly, Craig, before we leave? Just real quickly on the materials that are included with today's discussion. There's a CalBar website, and I'm presuming you just get the hyperlinks. But look through that. There's a lot of good material in there if you have questions. Some of it's a little older than others, but I would highly recommend going through that. It's really good stuff that they've worked for a long time on compiling just for lawyers, so they have answers to their questions and they can get some guidance additionally. Thank you.
Thank you. Well, we're out of time, and I want to thank Judge Mockler, Matt Guichard, the folks in the background, the back office who've put this together, all those who attended, and look forward to seeing you all in person very soon. Thank you all so much.
Thank you.
Thank you.
Thank you.